a 7-judge bench to hear a verdict that was given way back in the 1990s. Okay, and this is with regard to the cash for votes. That particular judgment has come up for a kind of an analysis again, or trying to reanalyze what actually happened. From a 5-judge bench, it is now going to a 7-judge bench for hearing. I'll just read out this aspect of it. The Hindustan Times has covered it in their copy as well. In March 2019, a 3-judge bench referred the appeal to a 5-judge bench as it involved the interpretation of a 1998 decision. So the court is trying to visit a judgment they had given in 1998. All right. Now, the Supreme Court on Wednesday had agreed to examine the correctness of a 25-year-old decision by a 5-judge bench, which held that members of parliament accepting bribes and voting or asking questions in the House will enjoy immunity available to legislators under the Constitution. That is to say that if an elected person is raising a question, taking money from a source, it need not be brought under prosecution. So that was what the decision they arrived in 1998. And that's what, you know, this cash for votes, when they say whether that person even voted for a particular, you know, bill, after taking cash, they come under a particular immunity. So that is how the 1998 decision was looked at. I think there was a lot of petitions against that particular aspect of re-examining that aspect of that decision. And 2019, it was referred to a 7-judge bench, and now CJI Chandrachud has decided to take up and re-examine that case. So it is going to a 7-judge bench. So it's going to be quite crucial when we look at that aspect of that debate. Now, this bench is going to also be headed by CJI. And we'll have a relook at the 1998 Constitution Bench decision in the P V Narasimha Rao versus State, after the decision was relied upon by a former member of the Jharkhand Assembly, Shibu Soren of the Jharkhand Mukti Morcha, who allegedly accepted a bribe from an independent candidate for voting in Rajya Sabha elections in 2012. So this is the background of that story. She sought immunity from being prosecuted for the offence, citing Article 194(2) of the Constitution, which grants immunity to MLAs for any speech made or vote cast in the House. So the provision states that no member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Basically saying that I can vote the way I want, I can claim immunity from this procedure. You cannot ask why I voted or why I raised a speech. So that is the basic aspect of that provision. So the corresponding provision gives immunity to members of the parliament is contained in Article 105(2). So a long time old decision on this, which is being reviewed right now. Now, what the CJI said is this: prima facie, at the stage, we are considering view that correctness of the majority view taken in P V Narasimha Rao case should be considered by a larger bench of 7 judges. So this is an interesting aspect of this particular case. But revisiting a 25-year-old case, a judgment, and especially on this aspect of whether bribery can be shielded, how do you in fact look at it?
I mean, I think the basic crux of the matter is that, you know, the Supreme Court is finally trying to, you know, go back and look, and then trying to send the message that legislators are also not above the law. I mean, if they have done something, if they are committing a crime, whether it's
because that gives you immunity, that you know, that particular aspect of it. I think that aspect is what they are trying to
figure out, because you know, you cannot go around, and if they have, I was actually we were doing the show, and we did a story also that, you know, the Supreme Court gave a ruling. You know, they were amicus told the Supreme Court that, you know, when a scam, when anybody is convicted, when it's a government servant, he gets suspended, he cannot perform. And when it's a politician, when it's a member of parliament, they have some kind of immunity, and they are only suspended for 6 years, and then they can come back and they can you know, claim their seats again. So that is kind of unfair when it comes to a case, both of them are convicted equally, when both of them have been proven that they are doing something, then what is the immunity for? Why are we giving them the immunity? I mean, we get it that we are talking about MPs here, we're talking about ministers here. Anybody can go against and file an FIR. They cannot be take up every case that comes against a public figure. But still, they are not above the law. If we have information about they should be treated as a citizen of the country, not as somebody who's above the law.
The question over here is also about, whether you voting on taking bribe or not, whether it can be shielded to a large extent or not, is that question. So anyway, it's a 25-year-old case that they're looking into. Let's see how it works out.